Thank you very much for joining us. Welcome back. Today we are discussing Cabinet Resolution 58 of 2020. This regulations deals with the regulations of procedures of ultimate beneficial owner. And we have prepared one comprehensive guide on this based upon this resolution. We'll try to understand what is the history, what is the reason behind the implementation of this cabinet resolution. We'll see the objectives. We'll discuss everything related to this resolution in detail. First of all, we'll take the overview of the cabinet resolution, cabinet decision 58 of 2020. There are total 20 sections in this resolution. The section 1 deals with the definition, then objective, then scope of the resolution, licensing and registration of the legal person. Section 5 deals with the identification, transparency and real beneficiary, then notification, real beneficiary register, nominal members, then registers of partners and shareholders, information availability, notification, registrar obligations, information chain, confidentiality, cooperation, administrative sanctions in case you are not implementing the cabinet resolution. Then grievances, if you have any grievances, how can you appeal, what is the timeline for this. This resolution will repeal one cabinet decision as well, we will see at the end. Then this is publication and enforcement. So before moving further, I have rearranged this information into this chart. I said what would be the history. We'll discuss the history of this cabinet resolution in detail. Then we will see section 2 objective 3 scope of UBO. This scope is applicable on legal person, which is the company, and registrar. Then we'll see legal person, what are the liability, what is the responsibility of the legal person related to itself, related to company itself. Then what is the responsibility of the legal person related to real beneficiary, board members, partners and shareholders. Then we'll see for registrar, what the power which has been vested to the registrar by the companies and obligation of the registrar. So this legal person will pass on this information to the registrar. Section 11 and section 14 of this cabinet resolution deals with the provision of information to the registrar. Then registrar will pass on this information to the ministry, and ministry will pass on this information to the concerned authorities in the state. They can pass information to the competent foreign authorities as well. And section 16 of the resolutions deals with this. And then there are some more sections as well, like we'll discuss in a separate category: information confidentiality, administrative grievances, repeals, and publication and enforcement. So let's start. What is the history of the cabinet resolution? History is money laundering and terror financing has become very hot issue across the globe. And to control this money laundering and terror financing, FATF, Financial Action Task Force, was set up in 1989. And the core objective of the Financial Action and Task Force, I'll say FATF, was to control the money laundering and to stop the terror financing. So FATF has introduced 40 recommendations. They have introduced 40 recommendations. Out of this, 9 special recommendations that deals with the money laundering as well as with the terror financing. So as of today, there are 39 member countries of the FATF, and there are 2 regional organizations including GCC, which are the member of the FATF. If GCC as a body is the member of FATF, means all the 6 GCC countries, they are liable to implement, they are liable to compliance. What are the guidance, what are the recommendation which has been issued by FATF. Moreover, FATF and OECD work together for the prime objective of stimulate economic progress, world trade, and prevent tax income. Periodically, both of the organizations are meeting and they are deciding what are the countries, what are the bodies which have not complied their recommendations, and based upon this, they are preparing the list of countries. They are classifying the country into the blacklist, and this OECD FATF blacklist, this is non-cooperation countries and territory, the countries which are non-cooperative, the countries which are non-cooperative countries, non-cooperative territories. They are preparing the list of those countries and publicizing this list, that these countries are not cooperating related to the laws of money laundering, related to the laws of terror financing. So they are preparing the list of non-cooperative countries and territories. So out of the 40 recommendations that we have just discussed, recommendation number 33 of the FATF that deals countries should take measures to prevent an unlawful use of legal person by money launderers. Countries should ensure that there is adequate, accurate, and timely information of the beneficial ownership and control of the legal person that can be obtained and assessed in timely fashion by the competent authority. So the crux is, they said, related to the beneficial owner, there should be adequate, accurate, and timely information. Moreover, they have defined the beneficial owner. This definition has been taken from FATF. They said FATF defines the natural person who ultimately owns or control. The person who ultimately owns, the person who ultimately controls, this person is called beneficial owner. So as we discussed, all the member countries and the related bodies, they are liable to implement the recommendations of FATF, And recommendation number 33 of FATF deals with the beneficial owner. GCC is a member of FATF. UAE is a part of the GCC. UAE is required to implement all 40 recommendations, including this recommendation 33 as well. So to implement the recommendations of FATF, UAE introduced one federal law 20 of 2018 related to the money laundering and counting the financing of terrorism. Later on, they have introduced bylaw with the cabinet decision 10 of 2019 under the money laundering require business licensing agency in the UAE to identify the ultimate individual beneficial owner of the business licensed by them. Now, they have brought cabinet resolution that will regulate how to identify the owner and what are the related documents related to this. That's why they have brought this cabinet resolution 58 of 2020. FATF point of view about UAE, FATF has issued one report on April 30th and 2020. This report was prepared with the mutual cooperation of FATF and FATF MENA. They both have prepared this report. The one detailed report you can find on the FATF site, as well as you can find one executive summary. I have shared the link of executive summary. I have taken this from the FATF site. So you can find comprehensive report. You can find FATF executive summary related to UAE on the FSC site. What has been written in the report related to ultimate beneficial owner? They said the United Arab Emirates recently strengthened its legal framework. They are appreciating it that the UAE is strengthening its legal framework to fight money laundering and terrorist financing. But as a major global financial center and trading hub, it must take urgent action to effectively implement FATF recommendations. They said UAE is facing significant complexity. The reason is UAE is a fragmented jurisdictional nature of UAE. The reason is they are asking, there is a fragmented jurisdictional nature of UAE because there are 7 emirates. There are 2 financial free zones and there are 29 commercial free zones. So they are asking, due to fragmented jurisdictional nature of UAE facing significant complexity to implement all these decisions. Moreover, they have highlighted, they said, UAE did not demonstrate that it was possible to get the information directly from legal entities, and to give the recent enforcement legislation, it was not clear that they held suitable information. They are saying very clearly UAE is doing excellent job, but there is a fragmented nature of jurisdictional nature, so UAE is facing some sort of complexity. But one thing they have highlighted very clearly, that the information was not available with the legal entities. Immediate information was not available with the legal entities. So I personally believe this UBO Cabinet Resolution 58 of 2020 has been implemented to make sure that legal information is immediately available with the entities, immediately available with the registrar. So I can summarize the history that money laundering and terror financing has become a global issue. To control the money laundering and terror financing, FATF was established in 1989. FATF has given 40 recommendations to control money laundering and terror financing. Recommendation 33 deals with the beneficial owner. GCC member of FATF, UAE is member of GCC. UAE has already introduced Federal Law 20 of 2018 and Bylaws 10 of 2019 to control the money laundering and terror financing. Now this Cabinet Decision 58 of 2020 has been introduced in extension of those previous decisions to regulate the ultimate beneficial owners procedures. So this is the history. I am pretty sure you will be able to know what is the reason why this UBO law is being implemented in UAE. Reason of implementation of UBO in UAE, we have discussed in detail what is the reason for this, but it has been given in the Article 3. They said the larger objective is to make sure the person who is the ultimately beneficiary, that person is not involved in the money laundering and the person is not involved in the terror financing. They said the resolution deals with the minimum obligations of the registrar and legal person. What is the obligation of the registrar and legal person in the state? To maintain the register of ultimate beneficial ownership and the registers of partners and shareholders. This is the core objective. Second, they said, this is the scope. Second, they said enhance transparency. The second objective is to enhance the transparency in the UAE business environment by imposing minimum corporate data disclosure and maintenance requirement on companies licensed or registered in the UAE. So we can say there are two main obligations. First of all, to maintain the register. This is the core objective. Second core objective is to bring the transparency. On the larger level, we can say the ultimate beneficial owner, the person is not involved in money laundering and terror financing. Thus, this was the reason that this was implemented. So if I'm asking what is the scope, on which entity this is applicable, on which bodies this is applicable, it has been written very clearly. They said the provision of this resolution shall apply to registrar and legal entities licensed or registered in the state, whether incorporated onshore or in free zones, except the following. So except these two categories: companies that are wholly owned by the government, federal or local, and its subsidiaries, UBO law will not be applicable on these companies. Moreover, they said the companies which are in the financial free zone, we have already discussed there are 2 financial free zones and 37 commercial free zones. And the 2 financial free zones are Abu Dhabi Global Market and DIFC Dubai International Financial Center. So this resolution will not be applicable on the entities which are in the financial free zone in Abu Dhabi Global Market and Dubai International Financial Center. Other than the entities, government entities wholly owned by the government entities, entities which are in the financial free zone. Other than this resolution is applicable on all entities, and this resolution is applicable on the registrar as well. Now we'll see what are the responsibilities of the company. We have already discussed that there are two major responsibilities of the company. First of all, the responsibility of the company related to the company itself. I'm always asking, this is basic information that companies are required to provide to the registrar. So company will provide basic information related to itself to the registrar. Moreover, the companies will gather the information about the beneficial owner. Company will gather the information about the partners and shareholder. Company will collect the information about the nominal director. Company will maintain the information, basic information related to itself, as well as the company will maintain the information of beneficial owners, partners and shareholders and nominee directors as well in the form of registers, and company will provide all this information to the registrar. We'll discuss in detail. The first thing is responsibilities of the company related to itself, which is called basic information companies will be liable to provide to the registrar. They said the company should provide basic data to the registrar upon submitting a license or a registration applicable, and these are the basic information that the company will be liable to provide to the registrar. These basic informations are name, legal form and articles of association of the company, address. Legal person is local, then address of the headquarters of the main place of business. If the legal person is a foreigner, then name and address of the legal representative in the country should be mentioned and evidence to the effect shall be provided. Then they said articles of association or any other similar document approved by the relevant authority. At the end they said names of the relevant persons who hold positions in the senior management of the legal person. Their data will be recorded in accordance with the passport, ID, number, issue date, expiry date and issuer. So this is the basic information companies will be liable to provide to the registrar. Moreover, it has been written in the company will not be registered with the existing person name. Legal person will not use his name other than his legal name and must be followed by the legal form LLC. Like LLC is the form of company, limited liability company, public joint stock company, PGS. So we will be required to maintain at the end of the name what the legal form of the company. Legal person name address should be in all correspondence. Name and address should be in all correspondence. Legal person should have a clear and detailed address in the state to be notified to the registrar. So this is a basic information company will be liable to provide related to itself to the registrar. Then what the company is required to do related to other parties that we have discussed. Other three parties are beneficial owner, partners and shareholders, and the third one is nominee director. So first of all, we need to identify who is the beneficial owner. It has been very clearly written in the Article 5 of the resolution that the beneficial owner is the person who owns or financially controls the company directly or indirectly. The person who is holding 25% of the equity, it will be considered beneficial owner. The person who has 25% or more of the voting power, the person will be considered beneficial owner. Or the person who directly or indirectly appointing or dismissing the majority of the directors, means if the person directly or indirectly has the powers to appoint or dismiss the majority of the directors, then it will be considered beneficial owner. They said if more than one person are owning or controlling the shares of the company, then all of them shall be treated as owners and controllers. Moreover, they said if UBO is not known, you are applying this criteria. This is the primary criteria. You are applying primary criteria, but you are not able to identify who is the ultimate beneficial owner. Then they said if you are not able to identify the beneficial owner by applying the primary criteria, then they said the natural person who exercises control over the legal person, it will be considered deemed beneficiary. And now you apply the second test to identify the ultimately beneficial owner. And if second test fail as well, then they said the person who is occupying the senior management position, that person will be considered ultimate beneficiary of the company. So 3 tests are there. First, the primary criteria, 25%, 25%, having a authority to appoint or dismiss the majority of the director. If first test fails, second criteria is the person who is controlling, the natural person who is controlling, who exercises the control over the legal person, that will be considered ultimate beneficial owner. If the second test has failed, then third test, and third test is senior management official will be considered ultimate beneficial owner. It is important to note ultimate beneficial owners is not necessarily the shareholder. They have given one example. Suppose there is one entity XYZ, this entity is in the free zone, XYZ is in the free zone, XYZ is being owned by a foreign company, this foreign company is ABC. Then owners of the foreign company ABC are 2 parties, P and Q. P is holding 50% and Q is holding 50%. So P is holding 50% of ABC, Q is holding 50% of ABC, ABC is holding 100% of XYZ, which is in UAE. So in this situation, my ultimate beneficial owners are P and Q. ABC is the shareholder of XYZ. P and Q are the ultimate beneficial owner. So it will be a challenging task in some cases to identify who is the ultimate beneficial owner. Transparency and real beneficiary. It will be the responsibility of the legal person, it will be the responsibility of the company, that the company needs to take reasonable measures to obtain, maintain appropriate, accurate and updated information of the real beneficiary on ongoing basis. So company will have to take the reasonable measures to keep the information, updated information on ongoing basis. But they said there are some exceptions, means the company will not be required to take the reasonable measures. So these exceptions are where the legal person licensed or registered in the state, company owned by the company listed in the organized market, and company is providing disclosure requirement as required by the authority where the company is registered, and these disclosures are providing adequate transparency. Then third, this is subsidiary company owned by the majority of them by the listed company. So if there are 3 exceptions are there, if these 3 categories are there, then the legal person will not be required to take the reasonable measures to update the information on ongoing basis. This is a real beneficiary notification. They said if the company or legal person become aware that there is a person who is a real beneficiary, but the person is not on the real beneficiary register, then they said the company will inquire about the status of that person. And if the person is not replying within 15 days from the date of inquiry, then the company shall notify the relevant person of this matter. And whenever this notification will be issued by the legal person and company, this notification will be containing evidence of issuing notification. What is the reason based on this legal person believes to be correct and requests the further information, provide any missing information. If the addressee doesn't respond to the verification within 15 days of the dispatch date, the legal person shall include the detail reported in the real beneficiary register. Legal person may rely on the information provided by that person unless the legal person believes and unless the legal person has reasonable ground to suspect the answer is misleading or wrong. So this is a process of how to inquire about the person who is not on the register, but the legal person feels the person is ultimately beneficiary, and how to issue the notification to that person, what are the contents of notification, what is the timeline, and if the person is required to believe on the information which has been provided by that person, or if in case the person is suspected, the person can deny, person can reject the information as well. So as we discussed earlier, legal company are required to maintain the register of real beneficiary, register of UBO. So this section 8 of the cabinet resolution deals with the register, what is the requirement of the register and what is the timeline related to this. They said company or legal person shall keep the information of each real beneficiary in the real beneficiary register within 60 days from the date on which this resolution is effective, which is 25th of August. Effective date is 25th of August. We'll see in the section later on. Or the date of the legal person presence means the date the legal person was registered. So the date the legal person was registered or within 60 days from the effective date of a resolution, legal person will be required to keep the information. And if there are any changes in this register, it is required to be updated within 15 days from the date the person or company is aware of. So what should be included in the register? They said the register should include the following information: full name, nationality, date and place of birth of the real beneficial owner, place of residence or the address to which the notification are sent, passport, ID, country and date of issue and expiry of the passport and ID, basis on which he became a real beneficiary of the legal person and date on which it acquired the capacity to become a real beneficiary of the company, the date on which the person ceases to be real beneficiary. All this information will be part of the register required to be maintained for the real beneficiary. Moreover, they said if the legal person doesn't present himself or acknowledging the information and detail of being entered a real beneficiary in the beneficiary register, the legal person shall notify, including the natural person, within 15 days from the date of being listed. I don't know, this is 30 days or 15 days. I'll check and I'll come back. I personally feel this is a 15 days. Moreover, in the next section, they said if a legal person may not register or execute any document change in ownership, in case there is a change of ownership, a statement that include whether the transfer will result in change in UBO or nature of change, it is required to be submitted to the registrar as well. So if there is changes in the register, a statement will be required to be submitted to the registrar as well. So moreover, at the end they said everyone who has a capacity or interest may apply to the competent court requesting the correction if there is wrong information in the register. So anyone who has the capacity, who has the interest, the person has a right to apply to the court for the correction in the register list or date of the name of the person or real beneficiary, not listing, unjustified delay. So for all these reasons, the person can apply to the registrar for the correction. Person can apply to the competent court in the register as well. So board nominal members. So first category we have just discussed. We have discussed how to identify beneficiary, how to keep the transparency, how to maintain the register, what should be the part and what should be the content of the register. If some person is suspected to be beneficiary, then how to inquire and how to issue the notification, what will be the contents of the notification. All these things we have just discussed. Now we are moving ahead with the second person. Second person can be board nominal members, and section 9 of the resolutions deal with this. They said the directors are the board members who act as a nominal member shall notify the legal person being a nominal member and provide information related to Article 10 thereof. So what they said, if someone is becoming a nominal member, they will be required to notify to the company, and notification timeline is if the person has become a nominal member before the publication date, then within 15 days from the date on which he acquires such capacity. In case the person, if the person was before, then within 30 days from the publication date. And if the person has become a nominal member after the publication of this cabinet resolution, then within 15 days from the date the person has acquired this capacity, or the person has become a nominal member. Nominal members data will be provided as required in the Article 10. So nominal members data will be provided. It will be part of the partners and shareholder register. If there is any amendment in the information, it will be provided within 15 days of such amendment to the company. Nominal member will inform to the company within 15 days. If the nominal member stop acting as a nominal member, this information will also be provided within 15 days to the company by the nominal member. Partners and shareholders. This is the third category, partners and shareholders. A legal person shall keep the detail of the data of each partner and shareholder in the partners and shareholder register. So this is the second register. Principally, companies will be required to maintain two registers. One for UBO, ultimately beneficial owner or real beneficiary. Second will be partners and shareholder register. This partners and shareholder register will be carrying the detail of the nominal board member, as well as they will be containing the detail of the trustee as well. We'll discuss in detail. So they said, related to the partners and shareholder register, the register shall include the following information: the number and class of shares that has been issued and voting rights associated with them, date on which the partner or shareholder was acquired. Third, for partner and shareholder who are natural person, then this will be part of the partners and shareholders registered. Their full name, ID, passport, nationality, address, place of birth, name, address of the employer, in addition attaching a true copy of the valid ID and passport. If the legal person is the partner or the legal person is the shareholder of the legal person, then in this situation, provided that the data 1 to 4, we have discussed basic information in the very beginning. Responsibility of the company related to itself, all those information will be provided for this legal person who is a partner or who is a shareholder of the company. The legal person shall update the registrar of any changes thereto within 15 days from the date of its knowledge. A legal person, if someone is acting as a trustee or someone is acting as a nominal board member, so the detail of the trustee, the detail of the nominal board member will be part of the partners and shareholders registered. Moreover, they said the partners or shareholder register will include the data of person represented by each trustee and nominal board member, means each trustee and each nominal board member to whom they are representing, the detail of that person will be part of the partners and shareholders registered. Provision of information, we have already discussed in the beginning. Company will provide information to the registrar. Registrar will provide information to the ministry. Ministry will provide information to the local authority. The ministry will provide information to the foreign competent authorities. So this section deals with the flow of information. Provision of information. Now, legal person or company, the company has maintained the register. The company has maintained the register of the partner. The company has maintained the register of the shareholder. The company has maintained the register of the trustee. The company has maintained the register of the nominal board member. The company has maintained the register of ultimately beneficial owner. The company has maintained all this information based upon the previous discussion that we have just now. Now, the company will provide all this information to the registrar. So what the company will provide to the registrar, they said the legal person shall provide information to the registrar of basic information, partner, shareholder within 60 days from the publication of this resolution or the date of legal person registration or license. Within 60 days they will be required to provide the information. Legal person can provide additional information as well as and when required by the registrar. Third, the legal person shall provide the registrar with the information at the time of incorporation. They are talking about the basic information, the company related to itself. At the time of incorporation, the basic information will be provided at the time of incorporation, at the time of licensing, at the time of registration, renewal. At all these stages or any of these stages, all basic information related to the company will be provided to the registrar. Fourth, in the fourth section, they said the company will provide the name of the natural person who is authorized to disclose the information to the registrar. And the registrar will be able to get the information from that person who has the authority to disclose the information to the registrar, but the company will provide the detailed name of the natural person. They said company who is licensed or registered in the state may not issue bearer share guarantee. So no legal person can issue bearer share guarantee. Sixth, information about the issuing share to person or board member identity will be provided in 15 days in case shares are being issued to the board of director members, and then this information will be provided to the registrar as well within 15 days. If the company is in the dissolution or liquidation process, then the liquidator will be liable to provide the information, basic information and information about the UBO, partner and shareholder register or true copy of this within 30 days from its appointment to the registrar. So means company, they are thinking to liquidate the company, liquidator has been appointed. Once the liquidator has been appointed, liquidator will be liable to provide the information to the registrar within 30 days of its appointment, and this information will be basic information about the company. This information will be based upon the registered related to the UBO, partner, shareholders or nominal director or trustee. They said the legal person, administrator, the liquidator and registrar, whatever the information registrar is getting related to the company which is in the dissolution or liquidation process, they said registrar will maintain this information for a period of 5 years at least from the date of dissolution, liquidations or demise. This word is been used for the trustee. So this is the information and related information timeline when this information will be provided to the registrar by the company or by the liquidator, and what is the timeline that the registrar will maintain all this information. Information change, this is registrar will keep up to date and accurate information, basic information about the UBO and partner and shareholders associated, and registrar will keep this information updating. In case of any changes, legal person, company, it will be responsibility of the company to provide all information about the changes within 15 days from the date of its amendment. Now the second category we discussed. The third category, registrar. What is the vested power to the registrar? What are the obligations of the registrar? Now information has been collected by the company. Information has been passed on to the registrar. What the registrar will do? First of all, company will empower registrar for the functional purposes that the registrar can pass on this information to his employees, to his subordinates, to his authorized person for the proper functionality of the registrar. This has been covered in the section first. Second thing, whatever the information is being provided to the registrar, they said keep a copy of the submitted documents to the registrar. Moreover, they said this request the person who has to submit the information or documents in case they are not provided to determine the place, time and place specified by the registrar and answer any questions related to the matter related to the submission of information. But this, they said the professionals like lawyers, like legal professional, like independent auditor shall be exempted from providing any information that they have got during the juridical procedures. So this section, I will say, this section 12 overall deals the power that has been given to the registrar for the proper functioning, and what will be that then they will be required to keep the data, keep the copy. This all should containing the place, time specified by the registrar, and there is some sort of limit that the professionals like lawyers, chartered accountants and legal professional, if they are getting anything during the juridical procedure, then they are exempted from it. Registrar's obligation. These are the obligations of the registrar. Now registrar has the information. Once the registrar has the information, registrar has some sort of obligation as well. What is the obligation of the registrar? They said the registrar first of all needs to provide the guideline model so that for the proper functioning and implementation of the related cabinet decisions. Provide adequate human resources to enable him to carry out the work duties effectively. Automate and classify the information. Registrar will automate the information. Registrar will classify the information so it can be exchanged with the concerned authority very easy and very quickly. Registrar will provide all this information within 6 months from the date of publication of the resolution to Economic Registry. Within 6 months, this information will be provided to the NER, National Economic Registry. Registrar will provide all this information within 6 months from the publication of this resolution. Provide data on legal person in the state and make it available to the public. So they said registrar will make the data available to the public related to the legal person, basic information. They are not asking the data about the ultimately beneficial owner, partners, shareholders, trustee, nominal director. No, they are not asking this. They are asking basic information related to the company. Registrar will make this data available, and this data includes description of their different types of shapes and basic features, their licensing and registration procedure for obtaining the basic information stipulated, and 1.4, this is the basic information related to the company, procedure for obtaining the data. So this will be basically, they will publicize how to get the data, how can you get the information 1 to 4, what will be the procedure, what will be the guideline. Basically the registrar core responsibility will be to make the process very smooth and very easy. Registrar will keep the information updating on ongoing basis. Whatever the register has been handed over to the registrar, we have discussed in the previous clause as well. If in case of liquidation or delisting or dissolution, if any information is being provided to the registrar, registrar will keep this information for a period of 5 years. Registrar will obtain up to date and ensure the accuracy of the UBO information. Maintain the basic information about the company, ensure that they are accurate, up to date, available to the public. So this is the basic information. So registrar, if I'm saying on overall basis, what will be the responsibility of the registrar? The first responsibility of the registrar will be to issue the guideline and models and procedure for the smooth implementation of the decision. Registrar will provide information within 6 months to the National Economic Registry, and registrar will keep the information updating on ongoing basis related to the owners, partners, shareholders or company basic information. Ministry, local and international cooperation. They said provision of information. Ministry will provide information, basic information about the company and UBO partners and shareholder to the concerned authorities upon request. International cooperation. Then ministry shall provide ways of international cooperation, provided that the cooperation includes facilitates access, exchanging of information, uses power to obtain information of the real beneficiary or on behalf of foreign counterparts. Then they supervise the implementations of the cabinet resolution. So core objective to provide the information to the local concerned authorities upon request and to provide information to the foreign competent authorities and ways ministry will keep coordinating, keep cooperation, and ministry will supervise the implementation, the international cooperation. So basically whatever the basically foreign competent authority, they will coordinate, they will approach the ministry will help them to get the information, ministry will supervise the related cooperations. All these things at the very high level, ministry will be involved. Some more information is there, that information confidentiality. Information will remain confidential about the UBO, partner, shareholder, nominal director and trustee unless the written approval has been taken by the respective person. Then this information will be shared. But there are some exceptions, and these exceptions are disclosure obligation as per law, in case international laws and agreement force in the state as per law, or this information is required to counter the terror financing or any anti-money laundering. So if in case this information is required, then and this information is required as per law, so this information will be provided by the ministry and the registrar without the written approval of the respective person. Otherwise, written approval of the respective person will be required. Administrative sanction will be applicable, may impose administrative sanction if this cabinet resolution has not been implemented by the respective legal person, and if the legal person has any issue with the administrative sanction, then within 30 days from the date of the notification, then the legal person may approach the respective authority for these decisions. So this decision 58 of 2020, they said it will repeal the decision 34 of 2020. At the end, they said the resolution shall be published in the official gazette and shall enter into force as of the day following the date of publication. So I think the registration, cabinet resolution 58 of 2020 was issued on 24th of August, assuming it has been published on 25th or 26th. So within 60 days, companies will be liable to implement this resolution. They will be required to maintain the register. They will be required to pass on the information to the registrar. So next is way forward. How can you implement this decision? We are just 3-4 days away from the date of implementation. First of all, try to understand, as we discussed earlier as well, there are 37 commercial free zone to financial free zone. This decision is not applicable on the financial free zone. 37 commercial free zones. Each free zone has its own registrar. So first of all, there will be 37 different types of format to provide the information to the registrar. Might be they have the same format, might be they have the different format. So all the registrar, in some cases, they have given some sort of extension for submitting of this information to the registrar. Some authorities are asking by 31st October, some are asking by 27th of October. Might be they will give extension as well. Might be they will not give extension. But what are you required to do? This process is very simple. What are you to gather basic information about the company? As we discussed, company is liable to provide the information related to itself also. So get the basic information related to the company. Second, identify UBO, partners, shareholders and nominee directors. Identify who is the ultimately beneficial of the company, who is the partner, who is the shareholder, who is the nominee director, or who is the trustee. Identify those people. Collect information about these peoples. Then maintain a register of ultimately beneficial owner and partners and shareholder, which will be carrying the information that we have discussed in detail. Identify mode of submission. Might be online, might be through form, might be physical submission, might be on the portal. You need to identify what, in which category, in which commercial free zone on the mainland you are, what is the requirement of the registrar, how can you submit the information. Identify the mode, fill the information, then submit the form to the registrar to the respective mode. Thank you very much for joining us. If you have any question you can drop us an email. Email has been given here. This is info@crestcooper.com. You can give us a call as well in case of any urgency. Definitely will be there to help you. Thank you very much for joining us. Have a lovely day. Bye bye. Thank you.
Thanks for watching the video. Click on the bell and subscribe to the YouTube channel.